Good afternoon. I'm Steve Van Houten, President of Lifetime Financial Advisor, and I'm very proud that you've joined us today for our second educational seminar entitled Estate Planning. We are excited about presenting our featured speaker. You will be impacted greatly on a positive basis for the information that you're going to receive today. We've been asked to really provide more content that's impactful and practical for our clients. And with no exception, today is going to be amazingly helpful for your planning and legacy planning for your families. I want to thank all our clients for your partnership and loyalty over these many years. We are now serving 4 generations of clients in over 44 states. And today we have a record number of attendees at this presentation today, representing 6 time zones across the United States, from New York all the way to Honolulu, Hawaii. So I'm just very grateful and proud for what we've built today. I'm very proud of our staff, and I think you'll really enjoy this time together. I'm going to bring on Luke Van Houten, who's going to help us navigate this afternoon. So thank you again for your business and your trust, and I'm very grateful. Go ahead, Luke.
Excellent. Well, good afternoon, everyone. This is Luke Van Houten. As Steve said, this is our second installment of our educational webinar series. You can expect these every 2 months, and we're thrilled to bring you some very impactful and actionable estate planning content. So first off, I want to say thank you on behalf of the entire team here at Lifetime Financial for your trust, your continued partnership and support as we navigate our lives in these ever-changing markets together. Before I toss it over to David to introduce Anne, our distinguished speaker this afternoon, I wanted to go over a couple of housekeeping items for our question and answer session. For those who joined last time, you'll know that there's 2 ways to ask a question during the Q&A time. The first way, at the bottom of your Zoom window, there is a raise hand button. If you click on the raise hand button, I will see that we have some questions in the queue. I will unmute your line or your computer for you to go ahead and ask that question and open the floor up. Afterwards, we'll put you back on mute and we'll continue with the next question. Similarly, if you prefer to type out a question, there is a chat feature below entitled Q&A. You'll see that at the bottom of your screen. If you prefer to type in a question, we will review those questions towards the end and try to get through all of our questions. So really thrilled about this afternoon. Thank you for taking time out of your busy schedules to join us today. And David, I'll toss it over to you to get the ball rolling here.
All right, thanks so much, Luke. And again, thanks everyone for joining the call today. We're really excited to introduce Anne Wenger to you today. I originally met Anne at San Diego State University, where she taught my graduate level estate planning course. I was impressed with her ability to communicate complex estate planning topics, make them easy to understand and learn. Since then, I've had the opportunity to introduce Anne to the team here at Lifetime, and we've introduced her to many of our clients as well to help with their estate planning needs. Anne is a partner at McLaughlin Legal and leads the trust and estate division of the firm. She advises clients on their estate plans, as well as assisting families with the trust administration process after a loved one has passed away. A native and proud San Diegan, Anne received her undergraduate education at University of Notre Dame, her law degree from Gonzaga University School of Law, and her Master of Laws degree back home here at University of San Diego. Recently, Anne was selected as a Super Lawyer Rising Star in 2021. Congratulations, Anne. Serves on the editorial board of the Journal of Individual Financial Management as a board member of the Boys and Girls Club of Greater San Diego Foundation. With that, everyone on the call, again, thank you so much for joining us. Anne, thank you so much for presenting to us today, and I'll pass the meeting to you.
All right, thank you very much. Thanks for having me. I appreciate the opportunity. So we'll get started today. Estate planning, as they've all mentioned, is an important topic. I'm also aware it can be a bit of a boring topic or a daunting topic. So we'll do our best to kind of keep things as entertaining as possible as we go through. So before I get started, I know that Steve mentioned that there are clients here from states everywhere. I am solely licensed to practice in California, so I am going to be referring to California specific laws. Many of these concepts apply no matter what state you're in, but certain of them will be California specific. So I just want you to all be aware of that as we go through. I have some PowerPoints, so I'm going to go ahead and share my screen, I think. Okay, perhaps not. View slideshow. Sorry about that. Okay, I think we're working now. Okay, so whenever I speak to anyone about estate planning, my preference is to always start with the why. Why are we doing this? Most people, your financial planner, your CPA tells you you need to get this estate plan in place, but you never quite understand why are we doing this process. So that's where I want to start. There are really two main goals that we're trying to accomplish here. One is what's going to happen to my assets after I pass away. So that's the main one that most people think of. And so we want to make sure that the assets are being transferred to the individuals that you would intend to receive your assets at the age where it would be appropriate for them to receive those assets. And then the big thing, and what we have on our slide here, is making sure that we avoid the probate process. So I'm sure some of you have had experience with probate previously. In California, it's a disaster. It takes a very long time for the assets to transfer out of your name and into the name of your children, your beneficiaries. It's all public information, so anyone can go down to the probate court and pull a record and see what did that person own, what were their debts, who got what. So most people prefer not to have that as public information. But the big thing here is that probate is expensive. So there are these set statutory fees that get pulled out of your estate, and that's based on the value of your estate. And these fees get paid to the attorney who is running the probate process, as well as to the executor of your estate. And so I have the little schedule there of how those rates work out. A basic example, if your assets are at $1 million, which, you know, if you own real estate in California, you get there pretty quickly. These fees are just a little bit over $46,000. So it is a surprisingly high amount that most people aren't aware of. So yes, putting an estate plan together is going to be an upfront cost, but that most people don't understand how heavy these costs can be on the probate side. So it's a tremendous difference between what you're going to pay to get your plan set up front versus what these probate fees will eventually be. That last point I have there, intestate succession, if you do not have any kind of an estate plan set up at all, now this is where the state law comes in and dictates who gets what out of your estate. So again, most people would prefer to dictate who gets their assets versus the state coming in and deciding who gets what. So that's one side, is avoiding this probate process, getting the assets to the correct people. On the other side is, and I would almost argue more important, we want to make sure we have a structure in place for if you're still living, but you've now become incapacitated and someone needs to be able to step in and manage your assets on your behalf. Someone be able to access your bank accounts, your investment accounts, manage those investments for you. Or then more on the personal side, someone able to make your medical decisions for you if you're unable to express those wishes yourself. So again, if we don't have this structure properly put in place, we're now back in that probate court, getting what's called a conservatorship put over someone. And that is when the court evaluates you, decides that you do not have the capacity to make any of these decisions on your own. They pull all of your legal rights from you and institute a conservator to make all of your decisions for you. So it's a very powerful thing. And so it's really a last resort that we'd like to avoid at all costs. So those are sort of our two big main goals: is what happens if I'm alive and incapacitated, what happens after I pass away. On this side of what happens after I pass away, one of people's main goals in here is we're trying to create a structure that will protect your children, or maybe not your children, nieces, nephews, friends, whoever it might be, that's going to be inheriting these assets. So how do we set them up for success, essentially, in what we are distributing to them? So various things that we'll touch on a little bit later, but the first bullet point is who should take custody. So if you have children that are under the age of 18, a really important part of estate planning is setting up your guardianship nominations. So we'll dive into that a little bit deeper in a few slides. Now, also, if your children are young, at what age should they inherit these assets? Most people do not want their child turning 18 and having access to $1 million, and then they've, run through that money by the time they're 23. That's probably not what you're hoping for your children. So setting up some kind of a structure where we can dictate how and when they have access to these assets that you're leaving behind. That can be done a million different ways. I have some clients who say once they turn 22, give them everything. I have clients who say, I don't want them to have anything until they're 65 because they want them to get their own job and get their own life going. And this serves as more of a retirement cushion for them. And then, anything in between that you can imagine. So creating this structure so that they don't become one of these sort of trust fund kids that we all hear about, where they're just relying on the money that they've inherited rather than making strides in their own professional life, whatever it may be. That last bullet point there, very important, may not apply to everyone, but always good to know, is what if you have a special needs child? And so your child, has some kind of a disability that would prevent them from working, earning their own income. When someone's in that situation, they will often need to be on public benefits. So again, in California, that would be Medi-Cal, in the United States referred to as Medicaid, or SSI is another program. And these are all what we call asset tested programs, or means tested programs, which they're going to look at what do I own, what's my income, and as long as it's below X amount, I will qualify for these programs that are going to help me live my life. Now, let's say that I inherit this lump sum of money. Because those are asset tested programs, I'm going to be kicked off all of these things that are helping me live my life. And yes, my inheritance might pay for what I need for some period of time, but eventually that money's going to run out, and now I have to go through all the rigmarole of trying to apply for these programs again. And so if there's someone in your life that is in that kind of a situation, a special needs trust is critical to put in place. And just very quickly, what that is that, again, if I'm the child and I'm on my public benefits, I inherit this money, but instead of it coming directly to me, it will be put inside a trust. So I never have direct ownership of it. Therefore, I'm still qualifying for these public benefit programs that I might need. And now my special needs trust can pay for things that my public benefits don't provide. So, maybe my Medi-Cal gets me a sort of standard wheelchair, but my special needs trust can get me a motorized wheelchair, something like that. So it just sort of enhances my life as a special needs person. So that's a really critical one that I see missed all the time. And then the child inherits the money directly, and now we're in sort of a world of hurt. Another thing I've talked about, your children being young or possibly having special needs. Another thing is maybe your children aren't very young, but they're just not great at managing money. They, maybe it's something completely innocuous, like they just like to go on a spending spree, or it's maybe something more serious, like they have some kind of an addiction issue, whether it might be a substance abuse or a gambling or something like that. Again, probably not a great idea to just dump $1 million in that person's lap. So part of what we really want to do in estate plan is be very honest about what our family situation is. And then again, try to structure this plan to really set our kids up for success in the future. Okay, so those are some of the general whys. I mean, there's a million whys we could talk about, but those are some of the general whys. So now I want to get into the how. How do we do this? So the primary vehicle for avoiding the probate process is to have your assets titled in the name of a trust. So as long as your assets are in a trust, they will not have to go through that probate process that we talked about on slide 1. So not subject to those fees, that never applies. Now, the thing here is that your assets have to actually be in the name of your trust. So you need, when I say you put something in your trust, that means you are transferring title on the asset. So instead of my house being owned by Anne Wenger, I've changed title. So now my house is owned as Anne Wenger as trustee of the Wenger Family Trust. So I mention this because this is something I see all the time, is that people, they create their trust, but they never actually transfer title on their accounts into it. So they come to me, they say, oh, we did a trust 15 years ago. And I ask, are your assets in it? They say, yes, yes, yes. They're listed on the last page of the trust. That means nothing. You need to look at your individual statements for all of your accounts and see, is it in the name of the trust or is it still in my name as an individual? So that's sort of my tip 1 to make sure everyone writes down, if you already have a trust, that is critical to take care of. I'm sure that your assets that are at lifetime have already been taken care of, but maybe you've got bank accounts or assets that they don't manage that you just want to check those things. So now, that being said, there are only certain kinds of assets that you can do that title transfer and put into the name of a trust. So this is going to be any real estate, bank accounts, investment brokerage accounts that are not part of a retirement plan. We're going to talk about retirement here in a second. If you own individual stock shares, you own interest in LLCs, S Corps, C Corps, all these things need to be in the name of the trust. And if that title's been transferred, again, no probate occurs. So that's the probate side of these trust assets. Then, of course, our other goal is what do we do in the event of incapacitation? So whatever's been put into the name of this trust, whoever is identified as the trustee of that trust is the person who has access to these assets. They can get into the account, they can write a check, they can pay a bill, they can change investments. Trustee is just the manager of these assets. So you're going to be your own trustee during your lifetime. And then within the trust document, you're going to have a list of successor trustees. And this is who is going to step in and either manage those assets for you if you're still living but incapacitated, or then after you've passed away, this is the person who is in charge of managing the assets, distributing the assets to all of the beneficiaries after your death. So that's how that works for planning for incapacitation. Then again, anything that's been transferred into the name of this trust is going to be distributed according to the terms of your trust. So that's all the things we were just talking about of, do the assets go directly to your children when you pass away? Do they get held in a trust for a series of years? How and when are they going to have access? The terms of your trust are what control what happens to everything inside the trust. For most people, your trust, if you already have one or if you're going to set one up, is going to be a revocable trust. And what that means is that it's amendable, it's changeable. So you might set up the terms of the trust one way today, and then in 10 years, 20 years, 30 years, you want to make a complete overhaul of that because now your kids are grown and they are okay to manage the assets, or maybe some circumstance has come up that you want to create a special needs trust, something like that. So those terms are always changeable. So that's our sort of first category of assets, are assets that can be put into a trust: real estate, bank accounts, investments, stocks, that kind of thing. Our second category of assets are things that you cannot put into a trust, or they're not typically put into a trust. So biggest things here are any retirement accounts. So, you know, IRAs, 401ks, 403bs, 457s, pensions, all of those things do not go into a trust. In general, life insurance policies do not go into a trust during your lifetime. Qualified annuities, health savings accounts, these things are non-trust assets, is how I'll refer to them. So again, we've got our two goals. What happens if I'm incapacitated? What happens after I die? So if it's not in the trust, now we're looking to who is named in the durable power of attorney document. That is the individual who's going to be able to access and manage these non-trust assets for you if you are incapacitated. So pull out your RMDs, whatever might need to be done. And then they're just what you think of as power of attorney. It's the person who steps into your shoes as a legal being. They can sign a contract on your behalf, or file your taxes for you, or call the phone company for you. Anything like that, this person can do on your behalf. So that's the incapacitation side of non-trust assets. Now, the probate avoidance side of these non-trust assets is where after you've passed away, the critical component here is how are your beneficiary designations set up on those accounts. So whether you remember it or not, at some point you would have set up beneficiaries. So for example, on your IRA, there would be a spot for a primary beneficiary. Typically, if you're married, that's going to be your spouse, 100%. And then there would be a spot for a contingent or a secondary beneficiary, and that may be your children. If they're quite young, it could be your trust even. But we must make sure we've got beneficiary designations on all of these non-trust assets, because that's the only way they're avoiding probate. So tip one was make sure your assets that can be in the trust, check all of your beneficiary designations and make sure that they are set up to the individuals that you want them to be listed at. Whether, maybe at one point you had your trust listed, but now your children are grown up, and so you should list your children directly as the beneficiaries. Big tip is, what if it was your ex-spouse that was listed as your beneficiary? There are certain types of assets that if you fail to change that beneficiary designation, your ex-spouse is still inheriting that money. So things like life insurance policies, retirement accounts that are governed by ERISA. So I'm sure that's not what anyone intended, but there's been a lot of cases about this, and the courts continue to hold that those beneficiary designations are what counts. So check your beneficiary designations is my hot tip number 2. So in a perfect world, all we would need is our trust and our power of attorney, because if it can be in the trust, it is, and if it can't be in the trust, it's got beneficiary designations. However, we, do not live in a perfect world. So our sort of third main financial document is our will. And so you still have a will when you have a trust, but really now it's just a backup plan. Your trust is really what controls what happens to all of your assets after you pass away. So now all your will says is any asset that I own when I die that I forgot to put in the name of my trust, or I forgot to list a beneficiary designation, your will says, take that asset, transfer it into my trust, and distribute it according to the terms of my trust. It's called a pour over will. The assets pour over into your trust. And so this is in place to just kind of sweep in anything that we have forgotten about. So key thing with that is that the only way that that still works and you can still avoid having to go through probate is if the total aggregate value of everything I own that was not in my trust or did not have beneficiary designations has to be less than $166,250 is the current amount. And you can see there when it comes to real property, that amount is even lower, $55,425. So if you kind of take a step back from all of this, that number, $166,250, is what triggers the probate process. So if I don't own a home and I have 20 grand in the bank, I don't need to worry about this trust and all of this. I mean, there may be other reasons, but in general, I don't need to worry about these things because even if I passed away, probate's not triggered because my assets are below 166,250. So in general, when your assets are in excess of that amount, that's when you want to start thinking about this planning, and especially if you own real property. So those are kind of the three main financial documents that we're dealing with. And then more on the personal side, we want to be sure we have an advanced healthcare directive in place. So I mentioned this briefly earlier, but this is the document where you are nominating who's going to step in and make your medical decisions for you if you're unable to express those wishes yourself. And then typically also in the document, you'll be listing the types of decisions you would want that person to make based on the particular medical circumstance that you're in. So these are really important documents to have in place. Probably many of you have them or have dealt with family and you've been their healthcare agent, but very important. I'm sure, well, depending on your age, everyone remembers the Terry Schiavo case from Florida, and that's sort of where this became big news. Is she was a 27-year-old woman, she was married, but she had no health care directive. She went into a persistent vegetative state. She had not identified a specific person to make her wishes, nor had she identified the types of wishes types of decisions she wanted them to make. And it turned into this, 15-year-long battle between her husband and her parents and went up to the Supreme Court and all of these things. So that's obviously an extreme example, but it's just illustrative of how important these things are to have in place. Sort of a quick side note, for any of you who have kids that are over 18, strongly recommend that you have them sign a power of attorney document and a healthcare directive. They, if they're 20 years old, or at least I know when I was 20 years old, I didn't have a sizable estate that I needed to do a trust and all of these things. But realize that once your kids turn 18, you have no legal authority over them at all. So, heaven forbid your son gets into a car accident and he's 20 years old and he doesn't have a healthcare directive, you can't talk to the doctors and make medical decisions for him. So, it's when you're not doing a full estate plan together, getting these documents, the healthcare directive, the power of attorney, is a pretty simple thing to do. I mean, frankly, there's a lot of online forms you could probably just use, because if it doesn't need to be tied in with the trust and the will and all that, it can be a fairly simple document. But I strongly recommend that if you've got kids over 18, have them sign these documents so you don't find yourself in that circumstance where they're incapacitated and there's nothing you can do about it. Okay, and then again, on the personal side here, I touched on this earlier, is this guardian nomination of who's going to take physical and financial custody of your minor children if something happens to you before they turn 18. I listed this on here, but this is really true for any of those roles of trustee, power of attorney, healthcare. Important to list who you would like in that role, but also almost as important is if there's anyone you specifically do not want to ever be appointed to any of these roles, put those in your documents as well. You know, but then particularly when it comes to guardians, you know, you want it to be someone that, of course, you trust their judgment, but also maybe their philosophy on life aligns with yours. So this is often a really hard thing for young parents to come up with of who they want to put in this guardian role, but very important, obviously, as we can all understand, to have something like that on file so that, again, if there's no one listed, this turns into family members petitioning the court to fight over who should be the guardian, and you know, would like to avoid that situation, of course. So the last slide I have here is just sort of certain concerns to be aware of. So again, I'll reiterate what I've already told to you is that make sure if you already have a trust that your assets are in the name of your trust, or if in the future you are going to create a trust, you don't just stop with signing the documents. You've got to go to the bank and go to the, you know, whichever financial institution and make sure that you do put those assets into the trust. When it comes to beneficiary designations, again, I said, you know, critical to make sure those are up to date and they reflect the individuals that you would like to see receive those assets. When it comes to the various agents, the trustee, power of attorney, executor, healthcare, think of, really put thought into who should be in those roles. A lot of people just sort of say, well, you know, oldest daughter first, and then, you know, the next oldest, and kind of go in sequential order. But maybe oldest daughter is not particularly adept at dealing with assets. Maybe she's not great at bookkeeping, things like that. So maybe she's not the right candidate. Also, if you have documents that you set up some time ago, 10 years ago, 15 years ago, go back and look at who those agents are, because I, again, have clients come in, they set up their documents a while ago where I'm reviewing them with them, and I say, okay, and your trustee is, you know, Joanne Smith. And they're like, oh, we haven't talked to her in 10 years, or she's passed away, or something like that. So review those agents and, again, put some critical thought into who's really the appropriate person to have in those roles. Again, back to this control over the care of your future and your children. So really, I already touched on this, but making sure that we are protecting them from themselves if they may have sort of bad habits or you know, aren't particularly financially savvy, but also protecting them from others. So maybe they have a spouse that you're not particularly fond of and are worried about that spouse having access to assets. Maybe they just have a, you know, a group of friends that you think would be able to easily influence them and have them make bad decisions with the money, or make bad investments with the money. So you're trying to protect them as best we can. We talked about the supplemental needs trust. Again, very important if you have any kind of a special needs person in your family that may be inheriting from you. This unmarried but long-term partner, this is a really more and more common thing that I see in my office, is people who've been together for quite some time, but they're just not going to get married for whatever reason might be. So in California, there is no such thing as common law marriage. We've all sort of heard that in movies or whatever it might be, but we do not have that. And so you do not gain any rights by living with someone for over X number of years in California. So if I am unmarried and my partner is in the hospital and someone needs to make his care decisions, I have no right to do any of that. They're not going to listen to me at all. And what may be even worse is that maybe my partner's family doesn't like me, and they have every right to shut me out of that hospital room and not let me see my partner. So, you know, probably don't want those consequences. So really important to get these documents in place, like a healthcare directive, power of attorney. Again, with these unmarried long-term partners, I have no right to inherit from my partner. So maybe we live in a house that we've lived together for 30 years in this house, and maybe it was always just in his name, or maybe it was held as what's called tenants in common. I'm out of luck, because whatever portion he owned, whether it was all or a part of it, that's going to wherever his either trust or will, or those laws of intestacy I mentioned earlier, is when the state kicks in and they say where your assets go. That's what's happening to those assets. And there are no provisions in those laws of intestacy for your 30-year partner. So estate planning, really critical for people who are unmarried. Put this in here, trust for pets. So this again is something that is increasingly common that I see, is that, you know, people, whether they ever had children or not, their pets are their children, and they have a lot, you know, strong concerns about what's going to happen to their pets, who's going to care for them, where is the financing going to come from. Again, depending on your age, you may remember who Leona Helmsley is, and she famously tried to create a trust for her dog that had $12 million in it. So anyhow, there have been court cases about this, and there are particular rules for how you can set these things up for pets. But that is something that I really increasingly am seeing in my clients that they want to do in their estate plans. That non-citizen spouses, again, just something to be aware of. If either spouse is not a US citizen nor a green card holder, we've got very different tax laws that apply. I wrote in there a Q.dot trust. I won't go all the way into what that is, but just be aware that if either one of you or both of you are not a US citizen, that you'd want to make sure that you make your estate planner aware of that, so that they can put in these provisions that will be more beneficial to you, since not all of our estate and gift tax laws apply to you. Was going to talk about sort of, it's almost like a makeshift estate planning that a lot of people do, and just want you to be aware of it and why it's not a great idea. So something that people will do in order to either try to avoid probate or to help in the event of incapacitation is to add one of their children on title to one of their assets. So whether it's adding them on title to their house, so that when I add my child, so that when I die, the house passes to my child, or I add my child to my bank account, my investment account, because I want to be sure that if I become incapacitated, my child can now sign on behalf of me, write a check, do whatever might need to be done. Seems like that could be helpful, but people are really unaware of the negative tax consequences that that can have. So one, when I add my child on title to my house, I am in fact gifting my child half of the value of my house. So I've now made a $400,000 gift to my child, which can bring in gift tax consequences. We won't get into the weeds with that, but brings in gift tax consequences. Alternatively, on I see that sometimes, but the one that I really see frequently is that I decide I'm going to put my daughter on my accounts so that she can sign and work on my behalf if I'm incapacitated. What people don't realize is that let's say I've got $200,000 on this account and I have 4 children. So my intention is that after I die, that account gets split 4 ways amongst my kids. But when I add someone onto my account, I am completely avoiding that result of giving all of my kids 4 equal shares. What I have now done is said daughter that I added to my account now has become, once I die, she owns that account herself. So all that $200 or $200,000, she can take that for herself. And so she has no reason that she has to give it to her siblings. That's one. Or maybe she's nice and she thinks, well, yes, I know, but what mom intended was that we each got 50 grand. So now my daughter writes a check to child 1, child 2, child 3 for 50 grand. Now we've got another gift tax consequence, because now instead of this being a tax-free inheritance from my account to my 4 children, it's now a taxable gift from my daughter to her siblings. So, so there's just a lot of unintended consequences when we're adding people to title of our assets in an effort to kind of, like I said, do a makeshift estate plan. So those were kind of some of the main things that I wanted to talk about, and I wanted to be sure we left time for questions. So I will stop sharing my slides, and maybe we can get into that.
Perfect, Anne. That's fantastic content and just a lot of things to be thinking about. And estate planning is such an important area where clients just need to be knowledgeable about all of the potential pitfalls of, not knowing what we didn't know. So we really appreciate a lot of the content that you've brought to our attention. I'll do a quick reminder for everybody in the audience. There's 2 ways to ask a question. First and foremost, you can click the raised hand button below, and that will pop up on my side, and I can unmute your line for you to ask a question. Similarly, if you want to click into the Q&A button down below, you'll be able to type in a question that way to tee it up. And it looks like we already have some comments and questions coming in. But to get the ball started, one thing that I've personally come across in some cases that we have from clients for retirement accounts, and where we have the opportunity to list a primary or contingent beneficiary, are there any cases where it makes more sense to list a trust as a primary beneficiary, let's say for perhaps a widowed spouse, or in the case of a minor child who would otherwise be listed as a beneficiary in some cases? Can you provide a little bit of color as to when it might make sense to make a trust as a primary or contingent instead of a human?
Yeah, so this is a tricky conversation, and particularly there was a new law put in place called the Secure Act that some of you may be familiar with, that really changed how we do planning with retirement accounts. And this was in, I think, the very beginning of 2020 when this came into place. So used to be much easier to list a trust as a beneficiary, and because prior to the Secure Act, without doing too much boring tax stuff, prior to the Secure Act, we used to be able to list a non-spouse as a beneficiary. So let's say I named my 3 children as the beneficiaries, and they could, once I died, they have to start taking out required minimum distributions immediately, but they used to be able to use their own life expectancy in order to stretch out this retirement account. They call it the stretch, where if I was, 39 when my parent died, I am using the life expectancy based on a 39-year-old, and that told me how much of a required minimum distribution I had to take out every year. The reason we care about that is because the required minimum distribution is taxable income to me when I pull it. So we used to have the ability for, if we had minor children, to say, okay, I don't want to name them directly, but I will name my trust. And if you had the proper terms in your trust, you could still take advantage of this stretching out the distributions over the life expectancy of the child. Secure Act came, and that's all been turned on its head. There is no longer the stretch of the distributions. So It still works for spouses, and there are some caveats there for special needs children, things like that. But now my children must, or whoever my beneficiary is, must pull out the entire balance of that account within 10 years of the date of my death. So instead of these small increments I could take over time, it's a chunk. And you don't even have an annual required distribution. It just has to at least be cleared out over 10 years. So I could take a tenth every year, or I could take it all at once, or I could take it all in year 10, or some combination of those. So we no longer, the trust is becoming less and less desirable as a place to funnel the assets into as a beneficiary, because we are stuck with this 10-year period. And there's more tax reasons, but I won't get too far into that. So when it comes to minor children, it's a little bit of a conundrum. We can still do that, but we have to be very careful about the language in the trust to ensure that they still have the ability to at least take it out over a 10-year period. When it comes to minors, so if I inherited it and I was 6 years old, that 10-year clock doesn't start ticking until I'm 18. So and then there's another rule, but it hasn't quite been clarified yet, that if I'm enrolled in a course of study, my 10-year clock doesn't start until I'm 26. We haven't quite figured out from the IRS what a course of study is. So what a lot of people are doing is saying, I don't want to deal with it going through the trust. I'm just going to either, if my kids are somewhat of age, I'm going to name them directly, or if they're minors, maybe we still go through the trust, or maybe we, and every company has different rules about this, but maybe we can identify that the beneficiary is going to be the child directly, but we can set up a custodian who's going to manage the assets for them until they turn 18 or 26, depending on this course of study rule. So that was a very long-winded answer of saying that another tip for clients is, if you have your trust set up as the beneficiary of your retirement account, that may have been appropriate prior to this Secure Act. It is a lot of times no longer appropriate. So may want to have that conversation with either your financial planner or your estate planner.
And I think that segues really nicely into the question of, it's really important to have these documents, but how often, what's the hygiene as far as revisiting them? Because, you know, your situation might not change, but the world around us may change with certain legislation coming through from DC. So
Right.
Can you just give a little bit of context for what best practice might look like? And for folks who don't have these documents set up yet, you know, for you and your clientele, can you give just a high level overview of what it costs to establish a trust, knowing that there is cost savings down the line in avoiding the probate process? So how often and what does that cost? I think that's a couple questions that have come through.
Sure. So as far as the frequency of review, I generally recommend to my clients kind of look through maybe every 3 to 5 years. If nothing in your life is changing, look through it every 3 to 5 years. Again, like I mentioned before, check out who you have identified as your agents, see if they're still the right people. Who do you have listed as your beneficiaries? Is that all still appropriate? But then aside from that 3 to 5 years, of course, if there's any major circumstantial change in your own life, so, you know, births, deaths, divorce, this, that, that you're going to want to, of course, revisit it during those times. When it comes to changes in laws, that's tricky. Some people really have their finger on the pulse of things. I'm sure a lot of people are aware of the possible estate tax law changes that are happening right now. But for other people who aren't interested in tax like we are, they maybe don't care about what the possible changes are coming through Congress. So as far as law changes, it's a little bit difficult, and you kind of have to either rely on your planner to, you know, maybe send you a letter that says, hey, just wanted you to know this change is happening. It may affect you, and so let's talk it over. But you know, that's not really a foolproof method. The question of cost is always so difficult, and everyone always wants to know the answer to that. And so it's really dependent, or I can only speak for myself. that it's dependent on two things. It's dependent on the complexity of your assets. So it's one thing if I own a house, investments, retirements, great. It's another thing if I own 3 different corporations, 10 different properties, you know, a partnership interest, that kind of a thing. So that is what changes the price. And then on the other side, what changes it is the complexity of the distribution of your assets. So again, it's one thing if I say after I pass away, equal shares to my children immediately. It's a whole nother ball game if I'm creating special needs trusts and I'm creating a trust structure because my children are minors and it's going to be divvied out to them over X series of years. And so it can be very complicated on that end as well. What I can generally say is that it's typically for all of these documents together when I'm doing them for a client is going to be somewhere between maybe like 1,800 to 2,500, something like that. But do not hold me to these numbers because it's all dependent.
You got it. One quick question, can we get a copy of Anne's presentation? The good news is this presentation is being recorded. So for anybody not on this call, as long as we registered and have your information, we'll be able to send this on through if there's somebody you'd like to share this content with. And another couple questions that have come through, we know about titling homes, brokerage accounts, bank accounts, and the like. What about valuable personality, such as a collectible car or valuable artwork? How do you title those types of things in the name of a family trust, or what do you do in those circumstances?
Right. So if anything has an official title document, you're going to do that title switching. But, you know, like jewelry or, you know, just like you said, some kind of an antique furniture or something that there is no title document, what you'll do, or what I do, is basically we just have a 1-page document that says, I am assigning all of what we call our tangible personal property to this trust, and I want the trust terms to govern it. And then within your trust, you can identify, hey, I know I want my wedding ring to go to little Johnny, and I know I want my watch to go to Susie. And so you can identify specific people to take those assets. But really, if there's not a title document, there's no official thing you need to do. Usually, most people will do this sort of 1-page blanket assignment of all of my stuff is considered part of the trust.
Got it. Quick follow-up question on that. What about a business checking account that's registered in the name of a sole proprietorship? Is that included or includable somehow within trust documentation, not necessarily being able to be registered because it has to be registered in the name of the business?
Right. So part of it would depend on whether the sole proprietorship runs under your own tax ID number or whether it has its own separate tax ID number. But yeah, sole proprietorships are tricky when it comes to incorporating them in the trust, because again, basically the best we can do, because there's not an operating agreement, there's not corporate bylaws, there's not these things. And so we handle that the same way as what I was talking about with tangible personal property, is you have a document that says, I am assigning all of my right, title, and interest to Anne Wenger, a sole proprietorship, to the Anne Wenger Trust.
Okay, that's helpful. Steve, do you want to ask the question? And this comes up from time to time. You know, we might have durable power of attorney on file. We have all the documents. We know who's going to be, you know, next in line. Maybe it's the eldest son or daughter. Can you? I guess I'll turn it over to Steve. But at what point does it make sense to, you know, provide access and start that transition process while there is still capacity? Steve, do you want to give a little more color on that?
No, absolutely. And this is such a timely discussion just on estate planning, and we see this all day long, disasters, what not to do. It ends very horribly for families. So thank you for your help today. So with trustees, we have either mom and dad are super organized and are really open for sharing things, and they want to include their capable adult child as co-trustees. So they'll bring them on maybe when they're 70, 75 years old, a little bit later. Other times, they're reluctant to do that. They're either stubborn or just afraid, or we don't want to talk about it, and they're just unwilling to do that, and they wait too long, and they have incapacity. The kids call me up, mom's losing it. What do we do? Oh my gosh, she's doing horrible things. She's giving money away. She's not feeding the cat. What do you do? What do we do? How do we help them?
Right. So this, as I see it all the time, just like you do. And so, just as you said, we kind of have these two scenarios. Ideally, I will have a conversation with the parent that is really saying, you know, because there's two ways to go. There's let's bring someone on right now. You can be co-trustees together. We're not pulling your power away and giving it to someone else. We're allowing you to act together. And so you still retain all the control that you want, but now, you know, Susie is just there in case you need it, in case you decide you're sick of writing checks and you're sick of dealing with this. She's available, but we're not pulling your power away. And I think a lot of the times, if you can deal with that conversation in a delicate way, most people are pretty open to doing it. Now, if they're not, which of course we have those two who just say, nope, I don't want anybody involved. This is mine and I'm going to be in charge. And they have every right to do that as well. What we have to do in that circumstance is that if they want to stay as trustee and all we have is a successor trustee waiting in the wings, typically every trust document will have somewhere in there verbiage that tells us how do we remove someone because of incapacitation.
Yeah.
And so typically it will say either we need 2 doctors' opinions, 1 doctor's opinion, something like that. And so now this obviously drags that process out and it becomes a little bit more hostile because mom doesn't want to be removed, but now we're dragging her in front of 2 doctors to have her evaluated and have those doctors write down mom is incapacitated and should not be managing things. And so then once we have these 2 letters, now our successor trustee comes in and takes over and mom's out of there. So it's not a great situation really for anyone to be in. And so I think if you can try to explain those scenarios to people, most will come around to, great, let's do the co-trustee thing now so that it's an either or. And if I get to the point where I can't do it at all, my daughter's already right there. She can seamlessly step in and mail those checks or whatever it might be. You mentioned power of attorney. It operates in a similar way. You can have 2 different kinds of powers of attorney. One is called an immediate power of attorney, which is just what it sounds like, that you sign it and the authority that that document grants is effective immediately. The other is called a springing power of attorney, which is just like what we were talking about with the trust, that the authority is not effective until mom's been declared incapacitated by those 2 doctors. So another thing for those of you that already have estate plans in place is you may want to check out your power of attorney and see, is it immediate or is it springing, and decide which one you might want, because this roadblock of having to get the doctor's opinions, it really slows down whatever needs to happen and can become very difficult and have a negative effect on you, even though your intention was just that this roadblock of getting the doctor's opinions was providing you protection from someone coming in and doing something wrong with your money. And what I always tell people is, if you think that whoever is your next in line in your power of attorney is going to do something nefarious with your money, you should not be naming them in your power of attorney at all. So my preference is to have an immediate power, especially when people get older in age. I mean, it's one thing if you're younger and you're all set, but as you start to get older in age, think about adding that co-trustee, thinking about making sure your power of attorney is immediate so that we can just have sort of a seamless transition.
Yes, absolutely. And we have a lot of clients, you know, we are in 44 states now. So when a client does a trust in California, for example, and they move to a more friendly tax state, which we see all that going on today, do you recommend that they meet with an attorney in that state just to review things? We always say that, but we have a hard time getting them to do that because they feel that, hey, I'm fine. Anne did my trust. She's amazing. Well, she is in California, but she's no longer as helpful to you if you move to Tennessee or Oregon.
Exactly.
Or Nevada.
Yeah. So it's tricky because just as you said, if they've paid to do their estate plan once, the last thing they want to do is pay somebody else to do their estate plan again. But it really, I think, is a great idea. So one, an estate plan validly executed in one state is honored in another state. So even though it was signed in California and it's drafted under California law, it still will apply to you as a, Texan or whatever it might be. So issues to think about though is, are you moving from a community property state to a separate property state or vice versa? Because we've got different laws about how those assets are managed, at death based on the state that you're domiciled in when you pass away. So that's one consideration. And then another would be, sorry, I just lost my train of thought. That if
you said inheritance, yeah, states have inheritance tax, some don't.
Yeah, states that have inheritance tax, absolutely. So for example, Oregon, they have a state inheritance or estate tax that is less than the federal estate tax that applies to everyone. And so if you move to a state that did not have a state estate tax like us up to Oregon, now we're dealing with a much lower estate tax number that we might need to do some more sophisticated tax planning that we wouldn't have necessarily had to do had you remained in California. And then what I was thinking is that beyond all of these things, one thing I would always recommend doing is having an in-state healthcare directive, because that healthcare directive is a document that if you need it, you want it available right now. And you don't want to walk into that hospital in Texas and they look at it and they say, oh, this was signed in California. We have to send it to the legal department and see if they're going to accept it. So those healthcare documents, I would always try to have a local one available to use.
Excellent. Thank you. Excellent. Luke, how many more questions do we have? The phones are lighting up.
Phones are lighting up. We have probably at least two more. And just a quick reminder, if anybody wants to ask a question audibly, I know a number have come through over the chat feature, go ahead and raise your hand and I will unmute your line for you to ask. And one question here, how legitimate is a last minute makeshift last will and testament? Or, what are some potential concerns and pitfalls over something that is not notarized or not witnessed? Can you just give a little context for a last minute buzzer beater, if you will?
Right.
Or a quick change that's contrary to the trust that was executed on the deathbed, last gasp. There's this scribble thing out.
Yeah.
Who wrote it?
So it's very hard to give an answer on that because we've got one answer if I'm dying and my two kids are there and we're all on the same page doing this together and it says everything goes to my two kids and we kind of get it scribbled out and both my kids are on board that this is what they want to have happen. Who's there to contest it, right? So that's always what you're worried about, is who's going to contest this document. And so if there's no one there to contest it, great. Or usually you're in good shape as long as it was at least somewhat validly executed. Now, on the other hand, I used to have a trust that said 4 ways, and on my deathbed, my one son came, and now he's magically getting 70% of everything. And he was my caretaker for the last 2 years, and now we've got suspicions of undue influence and real ability for those other siblings to contest what was done. Now we're back in our friend the probate court, and now we're in litigation and we're spending all of the money in the estate to fight this out. So really I know more than anyone that this is a topic that they don't like to think about it. They don't like to talk about it, but you are doing yourself a tremendous disservice by putting this off. And so the earlier you can do it, when you have capacity and you're making the right decisions, I mean, it is the best favor you can do yourself.
And also we see successor trustees or executor, mom and dad have passed. Maybe there's more than one sibling. One son or daughter is the trustee, but it's not doing the right thing.
Mhm.
We get calls, hey, he was supposed to sell the family house. I want to do this. Or we all have the terms, the guidelines, but the trustees not operating in a good fiduciary capacity. That's litigation, and it gets really nasty and it's really terrible.
Exactly right. I mean, that stuff comes up all the time. I mean, that's why the probate court is filled with all of these cases. Step one, if you do find yourself in that situation of I'm the sibling of the trustee and I think my trustee's not doing the right thing, is to either just yourself write a letter to the trustee or have an attorney write a letter to the trustee that says, hey, let me remind you of these fiduciary duties that you have. We are expecting this to be done by X date. And if, hopefully that oftentimes will get them moving and saying, okay, now somebody's watching me. I need to get this done. And then, of course, if it doesn't, now this is where you're filing actions in the probate court. Yeah.
Sad. It's very sad.
Yes.
Awesome. Well, hey, it looks like we actually have our first question coming through audibly. So we're going to unmute the line of Jeff Almaris, and we will maybe do one additional question after this to be mindful of time. Jeff.
Hi, can you hear me?
There we go. We have you live here, Jeff.
And I was just wondering about updating an existing trust that I have that's like 20 years old. I know that's probably a very smart thing to do at this point because a lot of our assets have changed, et cetera.
Yeah.
Go
So
ahead.
certainly after that, well, was it just more that general question? Or did you have something specific in mind?
Yeah, I was just curious, do you do that type of work and do you see that commonly done now?
Yes, so I absolutely do that kind of work, do it all the time. And especially, you said our assets, so are you married?
Yeah.
Okay, so particularly when it comes to that, there's been a huge amount of change when it comes to how trusts are managed for married couples. And again, without getting too in the weeds of the tax stuff, trusts used to be very frequently drafted in one way. And it was necessary in order to comply with the current estate tax laws that were in place for a long time. The estate tax laws have changed drastically, particularly since 2010. There are new laws in place that give bigger breaks to married couples as far as the amount of assets that they can pass to their beneficiaries after they pass away. And so those old provisions that were being used now are very frequently unnecessary. And in fact, they cause a real burden to the surviving spouse if those old provisions are still in play. So I would definitely recommend to anyone who is married and has a trust prior to 2010 to have that checked out to see, do we still need these old provisions, or are we in a place where we can simplify that trust and get rid of those old provisions and set up the spouse and the surviving spouse in a much better place after someone passes away?
Excellent question, Jeff. And I think that's a good segue too. If anyone has questions specific to them, feel free to reach out to us. We'd be happy, especially if you are a California resident, we'd be happy to funnel that question on to Anne and make her available as a resource and point of contact to determine if you're a good candidate to have some of these documents revisited and refreshed. We've had a number of clients go through that process with Anne, and we've received fantastic feedback as well. So for those California residents, especially those local to San Diego, Anne's a tremendous resource and would certainly be more than available to work through that with you. Doesn't look like we have any other hands raised, and we've worked through pretty much all of the questions here in the chat box as well. So
Luke, this is a real call to action, because for doing this business, financial planning, for over 40 years now, 40 years, we've served 4 generations of families. We're on the 4th generation. So we've done multi-generational planning for a long, long time. So all of us who have joined us today, we do this to help you reflect, do a lifeboat drill, look at your trust. What would happen if over coffee with your spouse or in a quiet moment with your adult children? But our greatest sadness in this business is people don't act early enough. They have good intentions, but if it's not executed legally, properly, we do the best we can, but we can't make you do that. So let's be just today as a real call to action to really secure your financial life and your legacy. Get more clarity leads to confidence.
Absolutely. I guess before I close things out, Anne, any final words on your end? You provided such tremendous content. This has been a really interactive and engaging Q&A session, but any final thoughts on your end before we wrap our time up here today?
No, I mean, I think I would really just echo what Steve said, is that there is, again, it's no one wants to talk about death. No one wants to talk about money. No one wants to think about what if something happened to you and your kids were still minors. But not thinking about it is just putting you in a way worse place than taking the time to just get through this process. And it can be a slog. I'm aware of that. I try to make it as enjoyable as a process as possible for my clients. But, we all recognize that it's not a fun thing to do, but it's just, you want your children to I assume you want your children to have as easy of a time as possible after you've passed away. And the last thing they want to be is fighting things out in probate court and paying these probate fees and dealing with, accounts that were never put into the trust and all of these things. It's a mess for them. And so, it's not like, oh, we have these documents in place and you pass away and magically they have the assets. There's still procedures that have to be, taken, but it is just so much, tremendously easier on them in the long run. So try to take the time to sit down, think about it, and get these documents done. And if you already have them done, get them reviewed. And then again, I'm a broken record, but make sure your assets are in the trust. Make sure you've got your beneficiary designations. That is the big key takeaways.
Super actionable, super actionable. And in closing, just a quick reminder, if anybody has any specific questions specific to them, go ahead and send us an email. We'll get you in touch with Anne. If you are out of state, we've got networks of other financial professionals across the country and would be happy to do some homework and provide you with the name of a trusted attorney in your local area as well. So on behalf of the team here, our entire team at Lifetime Financial, want to say thank you again for your continued trust and partnership and just the 4 generations that Steve alluded to. This is a generational business. It's a business that relies on trust and faith in a combined process together. So we will continue to meet you where you are and vice versa. And we just couldn't be more thrilled to kick off this content series. I want to do a quick plug. In a month and a half from now, we will have a year-end planning webinar talking through some tax strategies, some potential considerations, not only for 2021, but also in taking a peek down the pipeline, and seeing 2022 potential changes coming out of DC, what we can do now about those potential tax changes. So that's November 11th. Mark your calendars, 4 p.m. Pacific Coast time. Again, November 11th, Veterans Day at 4 p.m. We'll look forward to having you join us on that next call. So thanks again for your time, and thank you for your tremendous content and partnership. And everybody have a great rest of the week. And we'll have a rip-roaring start to October here before we know it.
Thanks for having me.
Thanks again, Anne.
All right,
Really appreciate
thank you.
it.
All right,
Thank you.
bye.
All the best, everybody.